The schedule of these live classes is provided on our website as well. Once the class is over, you can always have a look at these recorded lectures as well. And if somebody would ask, sir, what is the course fee? There is no course fee. This is a free-for-all initiative, but you can always support us by liking this video, comment under these videos, subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. So let's get started and look at question number 1. Which of the following is not mentioned in the Constitution? Judiciary is almost always in the news regarding appointments, regarding some controversies, some cases have been delayed. So let's look at some of the possible potential questions that might be asked from Indian judiciary. Which of the following is not mentioned in the Constitution? A. The judge of a Supreme Court shall hold office until he or she attains the age of 65 years. There are various provisions in the Constitution which ensure independence of judiciary. Judiciary should be independent. Which are these provisions in the Indian Constitution which ensure that judiciary is independent? Provision number 1 is this concept called doctrine of pleasure is not relevant for a judge. For example, ministers, they hold office during the pleasure of the president. Attorney General for India holds office during the pleasure of the president. But the judges of the Supreme Court as well as the High Court, they are provided security of tenure. That means they don't hold office during the pleasure of the president. They hold office till they attain a specific age. And the retirement age for a judge of the Supreme Court is 65, and the retirement age for the judge of a High Court is 62 years. And this is something which is mentioned in the Constitution, that the judges of the Supreme Court shall hold office till he or she attains the age of 65. So this is something which is mentioned in the Constitution. Number 2, in case of appointment of a judge other than the Chief Justice of India, the Chief Justice shall always be consulted. India is perhaps the only country in the world where judges are appointed by themselves. Because of the judgments in the year 1993 as well as 1998 and then again in 2015, which is known as the NJAC case, the judges are appointed by themselves. In a sense, the recommendation as to who should be the judge of a Supreme Court or High Court is recommended to the president by collegium. And this collegium system emerged because of the judicial verdicts in 1993 and 1998. So judges are in effect appointed by themselves, although the formal appointment letter is issued by the President of India. But this is mentioned in the Constitution. What is mentioned? Constitution says any judge of the Supreme Court or High Court shall be appointed by the President. But while appointing the judge, the President shall consult such of the judges of the Supreme Court and High Court as he may deem necessary. So original Constitution said that President shall consult while appointing a judge, any judge of the Supreme Court or High Court as he may deem necessary. But there was another condition. It is binding on the President of India to consult Chief Justice of India while appointing judges to the Supreme Court. Chief Justice of India shall always be consulted. So this is something which is mentioned in the Constitution. And the collegium system, which emerged because of 1993 and 1998 judgment, it has basically interpreted this phrase consultation as concurrence, which means whatever name is recommended by the collegium to the President of India is binding on the President of India. The President may ask for reconsideration of that name, but if the same name is reiterated by the collegium, it becomes binding on the President to appoint that individual as the judge of the Supreme Court or High Court. But what is mentioned in the Constitution? The retirement age for a judge of the Supreme Court and the High Court. What is mentioned in the Constitution? That while appointing judges other than the Chief Justice of India, the Chief Justice shall always be consulted. So there should be no room for any miscommunication in your mind. This is mentioned in the Constitution. Fourth, the qualifications of a Supreme Court judge. Who is qualified to be appointed as the judge of a Supreme Court? For that, we have a universal qualification that this person shall be the citizen of India. If you are a citizen of India, then you have to meet either criteria A or criteria B or criteria C. What is criteria A? You should be a judge of one or more high court for 5 years. If you are a citizen of India and you are a judge of one or more high courts for 5 years, you are qualified to be appointed as the judge of a Supreme Court. If not, then you should be an advocate in one or more high courts for a period of 10 years. If not, then in the eyes of the President, you should be a distinguished jurist. And please remember one thing, this qualification, that if you are in the eyes of the President a distinguished jurist, you are qualified to be appointed as a Supreme Court judge. But this qualification is not there for a High Court judge. What is the qualification required for a High Court judge? You should have held a judicial office for 10 years, or you should have been an advocate in one or more high courts for 10 years. There is no such concept of a distinguished jurist when it comes to a High Court judge. But if you are a citizen of India and you are a judge of a high court for 5 or more years, you are qualified. You are a citizen of India and you have been a practicing advocate in one or more high courts for 10 years, or in the eyes of the President, you are a distinguished jurist. This qualification is mentioned in the Constitution. But what is not mentioned is the procedure for the removal of a Supreme Court judge. C is the right answer. Why? Although the judges of the Supreme Court and High Court, they enjoy security of tenure. That means doctrine of pleasure is not applicable to them. But they can be removed from their offices based on a resolution passed by both houses of the Indian Parliament, that too by special majority. And then this resolution should be sent to the President, and the President will remove the judge of a Supreme Court or High Court. Please remember one thing carefully. This resolution, which is passed by both houses of the Parliament by special majority, this resolution is basically a statutory resolution. And this statutory resolution is binding on the President of India. That means the judge is appointed by the President, the judge is removed by the President as well. But the President cannot remove the judge on his own because there is no concept of doctrine of pleasure. The judge can be removed by the President based on the statutory resolution passed by both houses of the Parliament. On what grounds? What are the grounds on the basis of which the judge of a Supreme Court or High Court shall be removed from their office? The ground is proved misbehavior or incapacity. I think there is a confusion in your mind. Is this mentioned in the Constitution? Yes. The judge of a Supreme Court and High Court shall be removed from their offices on the grounds of proved misbehavior or incapacity. But how do we prove it? For that, the procedure is not mentioned in the Constitution. That procedure is mentioned under a law known as Judges Inquiry Act of 1968. The procedure for the removal of a judge of a Supreme Court or High Court is not mentioned in the Constitution, although the grounds are mentioned in the Constitution, but the procedure is mentioned in this law called Judges Inquiry Act 1968. This can be asked in your examination. Let's look at something else. Judges Inquiry Act, what does it talk about? This was in the news for the last 2 years, wasn't asked in 2020 or 2020, was asked in 2021, but can be asked again in a different fashion. How? The resolution calling for the removal of a judge, listen to me carefully, can be initiated in either Lok Sabha or Rajya Sabha. If, for example, this resolution calling for the removal of a judge is initiated in Rajya Sabha, then the members of the Rajya Sabha, 50 members of the Rajya Sabha, they have to write to the chairperson of Rajya Sabha. And if this resolution is to be initiated in Lok Sabha, then 100 MPs of Lok Sabha will have to write to the Speaker of the Lok Sabha. But the Speaker and the Chairman, they have a discretion. What is the discretion? They may or may not accept this motion, accept this request by the MPs. This is something which happened when Justice Deepak Misra, who was the first Chief Justice of India, against whom a resolution was tried to be introduced by the opposition in few years ago. But the chairman of Rajya Sabha, who is the Vice President of India, he did not accept this resolution. So the Speaker or the Chairman, they have a discretion in either accepting this resolution or not allowing this resolution. But if they accept, then a 3-member committee is to be set up. This 3-member committee will consist of a Chief Justice of India or a senior judge of the Supreme Court, will consist of a Chief Justice of any High Court, and will consist of a distinguished jurist. What is the role of this 3-member committee? The role of the 3-member committee is to investigate into these allegations of misbehavior and incapacity. And once they investigate, they will submit a report to the Parliament. And basis that report, the Parliament will then decide to either remove that judge or pass that resolution or decide to drop this resolution altogether. So this is the first question that we had to discuss, can be important for your prelims examination. Let's look at question number 2. I told you independence of judiciary is something which is very, very important. Dr. B.R. Ambedkar, he said the most important office under the Constitution of India is the office of CAG, Comptroller and the Auditor General of India. Next most important office is the office of the judge. But even a judge should be removed or can be removed if the judge is not performing well. But even then, we have to give independence to the judges. And which are these ways on the basis of which the Constitution provides independence to the judiciary? Number 1, they have security of tenure, something that we have discussed. They don't hold office during the pleasure of the President. Second, they can be removed, but only after a very complicated process of removal. And it is such a complicated process that till date, no judge of the Supreme Court or High Court has been removed based on the resolution passed by the Parliament. Third, their salary, their allowances, their pensions, they are all charged on the Consolidated Fund of India. Another important topic, any expenditure which is charged on the Consolidated Fund of India, Parliament can only discuss it. Parliament cannot vote. So Parliament, when the budget is being passed, can vote only on the expenditure made on the Consolidated Fund of India, not on the expenditure charged. We don't have to go too deep into these concepts. I assume you would have already understood these concepts. But what are the ways through which the Constitution ensures independence of judiciary? One is security of tenure. 2, they can be removed only after a very complicated process of removal. Third, their salaries, pensions are charged on the Consolidated Fund of India. What about the pension of a High Court judge. Very important concept. The pension of a High Court judge is also charged on the Consolidated Fund of India. The salary, the allowances of a High Court judge are charged on the Consolidated Fund of a state. But the pension of a High Court judge is charged on the Consolidated Fund of India. Another important way by which the Constitution tries to secure and ensure independence of judiciary is that the conduct of judges cannot be discussed inside the parliament. Inside the parliament, parliamentarians, they have an absolute freedom of speech and expression. They can say whatever they want to say, but there is one limitation. They cannot discuss the conduct of judges inside the parliament. Only in one instance, they can discuss the conduct of judges. They can discuss the conduct of that judge against whom the removal process is initiated in the parliament. For that judge, they can discuss his conduct. But if the judge is not to be removed, his conduct cannot be discussed. Why are we discussing this? Mahua Moitra, one of the honorable MPs of Lok Sabha from West Bengal belonging to the Trinamool Congress, she is alleged to have alluded to the former Chief Justice of India while she was giving a speech recently in the parliament. And that is how one member of the parliament, he invoked something called point of order. This is how you should cover current affairs. This concept might appear to you that this is part of the static content, but there is relevance of current affairs because this is something which was in the news. So if there is a limitation on the members of the parliament that you cannot discuss the conduct of judges inside the parliament, the allegation is that Mahua Moitra tried to discuss the conduct of one particular judge. And that is how one MP of the parliament issued or addressed or started, raised something called point of order. What is this point of order? There are rules of business and procedure in Lok Sabha, rules of business and procedure in Rajya Sabha. What if somebody deviates from these rules? If the rules say you can't discuss the conduct of judges, and if one MP is discussing the conduct of judges, so there is an MP who is violating the rules, somebody violating the rules, a member of the parliament can get up and raise a point of order. Dear Speaker, I have a point of order. What is this point of order? According to rule this, the member of the parliament has violated these rules. This is what is known as the point of order. So point of order can be asked in your prelims examination. But be that as it may, what is the question asking? Independence of judiciary from the executive and the legislature. What does it ensure? Also, there is no strict separation of powers between legislature, executive and judiciary in India, unlike United States of America, where there is a strict separation of powers. In India, we don't have a strict separation of powers because we are a parliamentary form of democracy. And in this parliamentary form of democracy, Council of Ministers, which is the executive, is drawn from the legislature. In fact, Constitution also, it says that there should be separation of powers between executive and judiciary. So Constitution does not say that there should be separation of powers between the legislature, executive and judiciary. Constitution only says that there shall be separation of powers between executive and judiciary. Where does it say this? Directive Principles of State Policy. Article 50 of the Constitution talks about separation of executive from judiciary. But that is separation. This is independence. And if judiciary is independent from executive and legislature, what does it ensure? It ensures rule of law. And this rule of law was in the news 2 days ago or a day ago when there was a member of the Legislative Assembly of Gujarat, Mr. Mewani, who was arrested by the Assam police and then taken to Assam. And there, according to the court, a false case was hoisted on him, the case of an assault on a woman police officer. We don't have to get into those controversies. But the court said something important, significant. The court said, the Assam court, the Guwahati High Court, it said that there is rule of law in India. and independence of judiciary ensures rule of law. And what is this rule of law? Nobody shall be deprived of his body or goods except for a breach of law. If I violated any law, my life can be snatched, my property can be snatched. But if I have not committed any crime, I should not be sacrificed of my liberty and life. Rule of law says anybody can sue or be sued. You can file a case against me, I can file a case against you. So there is rule of law. And if judiciary is independent, which means if somebody has been wrongly arrested by the executive, judiciary is independent, will set that individual free. That means independence of judiciary will ensure rule of law. Independence of judiciary will ensure realization of the human rights, the fundamental rights that we have. Who is the guardian? Who is the protector? Who is the custodian of these fundamental rights? The Supreme Court. That's why whenever your fundamental rights are violated, you can approach the court under Article 32 of the Constitution. But not just Supreme Court. You can also approach High Court under Article 226 of the Constitution. So if judiciary is independent, it will ensure the realization of your human rights. And there are so many papers, so many research papers, so many popular papers which say that if judiciary is independent, it also leads to prosperity and stability of the society. This option is something which might have confused you, but keep this in mind. If the judiciary is independent, it ensures prosperity and stability of the society as well. So the question is asking, which of the above statements is or are correct? D. All of the above is the right answer. Let's look at another question. Which of the following types of cases, in which of the following types of cases, the number of judges on a bench cannot be less than 5? And any bench, the number of judges who hear a case, and a case is known as a constitutional case. The Constitution says any case which involves interpretation of the Constitution, any case which involves questions on the Constitution should be decided by a bench of not less than 5. And this bench of not less than 5 judges is what is known as a Constitution bench. There are some important constitutional cases pending before the court. For example, the actions of the Union government on Article 370, 35 capital A, on electoral bonds and various other Citizenship Amendment Act, on, let's say, the reservation for economically weaker sections of the society. All these cases are to be heard by a constitution bench. That means a bench of not less than 5 judges. But the question is asking, and all these cases are in the news, the question is asking, in which of the following types of cases the number of judges on a bench cannot be less than 5? Number 1, cases involving interpretation of the Constitution. Yes. Number 2, advisory jurisdiction under Article 143. What is Article 143? Under Article 143, Supreme Court acts as the advisor of the President of India. The Supreme Court the President can refer any matter to the Supreme Court, asking the views of the Supreme Court on this matter. And in this advisory jurisdiction, this case can be heard by not less than 5 judges on a bench. So this is also correct. But death penalty cases, there is no requirement to have more than 5 judges or 5 or more judges. Even 2 judges can decide on the death penalty cases. So select the correct option from below. 1 and 2, B is the right answer. Let's look at another question. Statement number 1. The Constitution makes no provision for the appointment of temporary or acting judges of the Supreme Court. Statement 2. The seat of the Supreme Court can be shifted from Delhi to any other place by the Chief Justice of India only on the recommendations of the Collegium. there is no concept of a temporary or an acting judge of the Supreme Court. This statement is correct. But there is a concept called ad hoc judges. Very important, was in the news recently. There is something called quorum. For example, a case is to be heard. It's a constitutional case. The number of judges should not be less than 5. But there are less number of judges in the Supreme Court. That means the burden on the Supreme Court is large. We are not able to ensure the quorum. What the Chief Justice of India can do, Chief Justice of India, with the consent of the President of India, what the Chief Justice can do, he may ask a sitting High Court judge to attend the proceedings of Supreme Court. The number of judges who are about to get retired from the Supreme Court is growing. So there was a talk that we should have ad hoc judges in place. There is no concept of temporary or acting judge of the Supreme Court, but there is a concept of an ad hoc judge. And who is this ad hoc judge? When there is no quorum, the Chief Justice of India, with the prior consent of the President of India, what he can do, he can ask the sitting judge, a sitting judge of the High Court, that you please attend the proceedings of the Supreme Court. This is what we know as the ad hoc judge. But there is one more thing. Can a retired Supreme Court or High Court judge be asked to take part in the proceedings of the Supreme Court? Can a retired judge of a High Court or a Supreme Court be asked to take part in the proceedings of the Supreme Court? Yes. One very important point for your prelims is that with their consent, there is no compulsion. The Chief Justice may ask a retired judge of Supreme Court or High Court, retired judge. Ad hoc judge is a sitting High Court judge may be asked to participate in the proceedings of the Supreme Court. But here we are asking a retired High Court judge or a Supreme Court judge to participate in the proceedings of the Supreme Court. Here, the consent of this judge, this retired judge, is necessary. He cannot be compelled. There is no compulsion. There is no force. No force can be used to compel this retired judge to participate in the proceedings of the Supreme Court or High Court, Supreme Court. So this is a very important statement. What is the question? The Constitution makes no provision for the appointment of temporary or acting judges of the Supreme Court, correct? The seat of the Supreme Court can be shifted from Delhi to any other place or even places by the Chief Justice of India only on the recommendations of the Collegium. This is wrong. Which of the above statement is or are correct? Only one, A, is the right answer. According to Article 130, the seat of the Supreme Court shall be Delhi, or the seat of the Supreme Court shall be shifted to any other place or places by the Chief Justice of India with the approval of the President of India, not the Collegium. That's what makes statement 2 incorrect. Which of the above statements are correct? A, only one is the right answer. Let's look at another question. In which of the following matters can the Supreme Court withdraw a case pending before a High Court or High Courts and dispose of the case itself? Lots of cases which were in the news in the last 1 year, whether the cases deal with the love jihad cases or loudspeakers or hijab. There were cases which were pending in many courts as well. That is why we have picked up this question. The question is asking, under which of the following matters in which of the following matters can the Supreme Court withdraw a case from the High Court and decide to dispose of this case itself? Which are these instances? Which are these matters? Matter number one, if there is a case which is pending in the Supreme Court and similar case or the questions raised in the case are also pending in any other High Court or High Courts. So similar case. What the Supreme Court can do, it can withdraw the case from that High Court and decide to dispose of itself. This is one instance. Second instance is, if there is a case, similar case, let's say the controversy on the hijab. This case is pending in Karnataka High Court, this case is pending in Madras High Court, this case is pending in the Calcutta High Court. So there is a similar case with similar substantial questions pending in more than one High Court. What the Supreme Court can do, can withdraw this case from all these High Courts and dispose of itself. So the statement one is, when cases involving same or substantially the same questions of law are pending before the Supreme Court and one or more High Courts, correct? When cases involving same or substantially the same questions of law are pending before two or more High Courts, correct? Both A and B, C is the right answer. But one important thing here, which can be relevant for your prelims examination. How can the Supreme Court decide to take that case, to withdraw that case from all the High Courts and decide to dispose it of itself? Under three conditions. Either the Supreme Court will decide on its own that we want to withdraw these cases and dispose of itself, or on the submission by the Attorney General for India. Very important point. Attorney General for India may ask the Supreme Court that you please withdraw all these cases from different High Courts and dispose these cases yourself. Or on the basis of the submission made by a party. For example, you and me, we are parties to this case. We may approach the Supreme Court and say that these cases of substantial nature, similar nature, they are pending in more than one High Courts, they are pending in Supreme Court as well, so please take it up yourself. So under these three ways, on its own by the Supreme Court, on the submission made by the Attorney General for India, or on the basis of the submission made by the party, by one of the parties to this case. In these ways, the Supreme Court can withdraw a case and decide to dispose of itself. Let's look at another question. Consider the following statements. To increase the number of judges to the Supreme Court, a constitutional amendment bill under Article 368 is required to be passed by the Parliament. 2. At the time of the commencement of the Constitution, the Supreme Court consisted of a Chief Justice of India and 7 other judges. If we need to change, increase the number of judges, for that we don't have to take the recourse of Article 368. For that, what Parliament has to do? Parliament has to pass a law, and through this law, Parliament can increase the number of judges. And this is what has happened as well. The number of judges have been increased. Now we have a Chief Justice of India and 33 other judges. So in total, we have 34 judges. So increasing the number of judges to the Supreme Court can be done by the Parliament through an ordinary law, and this ordinary law should be passed by simple majority. So you don't have to take the recourse of Article 368, use special majority to increase the number of judges. This statement is incorrect. But yes, at the time of the commencement of the Constitution, on 26 January 1950, we had a Chief Justice of India and 7 other judges. And these 7 other judges are also known as puisne judges. The Supreme Court shall consist of Chief Justice of India and not more than 7 judges. This was mentioned at the time the Constitution was enacted. So, which of the above statements are incorrect? This is where you have to be very careful. You know the first statement is wrong. You know the second statement is correct. But the question is asking which of the above statements are incorrect. So, A, only one is the right answer. Correct? Let's look at another question. And after Judiciary, we will now shift to the Parliament, because Parliament is also in the news. Because of farm laws, Parliament is in the news, legislatures are in the news, because some MPs have been suspended as well. Some MPs have been thrown out as well. Parliament is in the news because there was ruckus, pandemonium, disruption inside the Parliament. And that is why there are commentators who say India is a functional democracy without a functioning Parliament. Correct? Incorrect? That's something that we will discuss in mains examination. But let's look at some of the questions, key topics, key issues regarding the Parliament of India. Number 1, Rajya Sabha was first constituted in 1950. Correct? Incorrect? You tell me. Half of the members of the Rajya Sabha retire every 2 years. Rajya Sabha, which is known as the permanent house of the Parliament, the upper house, which was not subject to dissolution. Rajya Sabha was first constituted in the year 1952. But how do we ensure, which means statement 1 is incorrect, but how do we ensure permanent nature of Rajya Sabha? We ensure by ensuring that 1/3 members of the Rajya Sabha retire every 2 years. So even statement 2 is incorrect. Not half of the members retire every 2 years, 1/3 of the members retire every 2 years. Which of the above statements is or are incorrect? Both these statements are incorrect. C is the right answer. Regarding Rajya Sabha, we have 3 special powers which are available to Rajya Sabha, which are not available to the Lok Sabha. One special power is under Article 67 Clause B, which deals with the removal of the Vice President of India. Vice President, if you have to remove the Vice President, this process can be initiated only in Rajya Sabha. That's the special power of Rajya Sabha. Second, Article 249. If Parliament of India wants to pass a law on a state list, that too in national interest, Parliament cannot do that unless and until Rajya Sabha passes a resolution by 2/3 of the members present and voting under Article 249. So a resolution passed by Rajya Sabha under Article 249 by 2/3 of the members present and voting, because Rajya Sabha says that it is in national interest that Parliament should legislate on a state list. This is a special power of Rajya Sabha. And the third special power is Article 312, creation of a new All India service. Who can create a new All India service? Parliament. But Parliament cannot initiate it on its own unless and until Rajya Sabha passes a resolution by special majority under Article 312. Once Rajya Sabha, which is known as the Council of States, which is known as a house of the Parliament which defends the interest of the states. That is why whenever Parliament wants to create a new All India service, for that a resolution should be first passed by Rajya Sabha under Article 312. These are the 3 special powers of Rajya Sabha which are not available to Lok Sabha. And at the same time, Rajya Sabha election is done through a system of open ballot. Very important point. Second, there is no reservation for SCs and STs in Rajya Sabha. Reservation is also in the news. EWS reservation, SC/ST reservation, Anglo-Indian reservation. So please understand, there is no reservation for SCs and STs in Rajya Sabha. So which of the above statements is or are incorrect? C, both are incorrect. C is the right answer. Let's look at another question. The President of India addresses both houses of the Parliament together in which of the following instances? President addresses both houses of the Indian Parliament. In a similar way, the governor of a state also addresses the Legislative Assembly, or the states where there is a bicameral legislature, where there are two houses, Legislative Assembly and Legislative Council, the governor also addresses. In the news because the governor of Telangana, she was not asked to address the both houses of the state legislature in Telangana, which is customary. So it is customary that every year when the new session begins, the first day of this new session, the governor addresses both houses of the state legislature, or the president addresses both houses of the Indian Parliament. This was not done in case of Telangana. Why? Because the Telangana government said that the legislature was only adjourned. Legislature was not prorogued. The session was not prorogued. So it is only when the session is prorogued that the session comes to an end. So this session, which we are convening right now, is not a new session. It's basically the continuation of a previous session. So for that, we don't have to call the governor to address both houses of the state legislature. That was the controversy. And after that, few statements were raised by the Honorable Governor of Telangana. Some statements were made by the son of KCR, the Chief Minister, Mr. KCR's son. We don't have to get into those controversies, but this is something which was in the news. So what is the question? The President of India addresses both houses of the Parliament together in which of the following instances? Number one, at the commencement of the first session after each general election to the Lok Sabha. Correct? At the commencement of the first session each year. Correct? And this President's address, the text is provided by the Council of Ministers. Whatever President is going to say, that's not the discretion of the President. The text of the speech is basically prepared by the Council of Ministers, presented to the President, and the same speech is then delivered by the President. There have been instances in the past 1 or 2 years where the text which was provided by the Council of Ministers to the governors have deviated from these texts. So governors, they have been saying something extra. They have been skipping some portions which were provided in this text by the Council of Ministers. That is why this is in the news. Third, to discuss a bill on which there is a deadlock between the Rajya Sabha and the Lok Sabha. No. Whenever there is a deadlock on a particular bill between Lok Sabha and the Rajya Sabha, how do we resolve this deadlock? This deadlock is resolved when the President notifies a joint sitting of the two houses. But in this joint sitting, the President does not address. This joint sitting is presided over by the Speaker. This joint sitting is not addressed by the President of India. So the President of India addresses both houses of the Parliament together. In which of the following instances? 1 and 2, B is the right answer. I'll take a couple of minutes more on this adjournment. Why? Because the government of Telangana says that we don't have to have the governor's address in the first session of this year because it was not a new session. It was the continuation of a previous session, which means the session or the legislature was only adjourned. It was not prorogued. What is the difference between adjournment and prorogation? Adjournment is a brief interval in an ongoing session. Let's say the budget session is going on. If there is a brief interval can be lunch break. Brief interval can be, let's say for example, we have budget. When the general discussion takes place on the budget, then for 3 to 4 weeks the House is adjourned, because this is where the departmentally related standing committees, they discuss all these demands for grants. So the House is adjourned. Adjournment does not end the session. It is still the budget session. So adjournment is only a brief interval in an ongoing session. Prorogation is the termination of the session. And the power to adjourn the House, this power is given to the presiding officer. So presiding officer of Lok Sabha, Rajya Sabha, State Legislative Assembly, Council, they have the power to adjourn the House. But who can prorogue the session? This is done by the President. Again, President does not do this on his own. President does this only on the advice of the Prime Minister and his Council of Ministers. To be more specific, this advice comes from Parliamentary Committee or Committee of the Cabinet called Cabinet Committee on Parliamentary Affairs. And there has been a change in this Cabinet Committee on Parliamentary Affairs as well. Previously, this Cabinet Committee on Parliamentary Affairs used to be headed by the Home Minister, but now it is headed by Defence Minister. These are important points relevant for your examination. Let's look at another question. Consider the following statements regarding the motion of thanks. Once the President addresses both houses of the Parliament, then after the President's address, there is a discussion on this motion of thanks. We thank the President for his speech. And once this discussion is over, there is also voting on this motion of thanks. This was in the news. Let's look at this question. Half an hour, this is a slightly tricky question. Tricky in the sense is not mentioned in lots of books that you read on Indian polity, but this is something related to current affairs, can be asked. Half an hour after the President's address, both the houses of the Parliament meet in their respective chambers, where the copies of the President's address are laid down by the Union Minister of Parliamentary Affairs. Correct or incorrect? Let me know. Members of the Parliament are free to speak on all sorts of matters, but excluding those which are not specifically mentioned in the President's address. What do you think? Can you think of it? I'll give you a couple of seconds. Let's say 20 seconds. Please think on this question and let me know what's the answer. You can't let me know, but still, what is the right answer? And there are close to 2,500 students watching this class right now. So there are 2,500 very serious aspirants. So why don't you just press the like button? Press the like button and let's discuss the answer. Half an hour after the President's address, both houses of the Parliament meet in their respective chambers, where the copies of the President's address are laid down by the Union Minister of Parliamentary Affairs? No. By the Secretary General of Lok Sabha. And it is this Secretary General of Lok Sabha which was in the news. In the Rajya Sabha, it is laid down by the Secretary General of Rajya Sabha. So, Secretary General, which is a permanent position in our parliamentary structure, it is this office which is responsible for tabling this President's address. Half an hour after it is done, it is placed before the House. So not by Union Minister of Parliamentary Affairs, this is wrong. members of the parliament are free to speak on all sorts of matters, excluding those which are not specifically mentioned in the president's address. Including. That's what makes statement 2 incorrect. The members of the parliament can speak on any issue, even if that issue is not touched upon by the president's address. For example, a few years ago, the members of the Rajya Sabha, they said, we regret that in the president's address there is no mention of corruption. So the members of the parliament are free to discuss any issue, including those which are not specifically mentioned in the president's address. That's what makes statement 2 incorrect. Select the correct option from below. Neither 1 nor 2, both these statements are incorrect. D is the right answer. Let's look at another question. The Constitution of 104th Amendment Act 2019 deals with which of the following? There have been very important constitutional amendments made in the past 5 to 7 years. The first was, and you may be asked to match the following type question. You may be asked what is 100th Amendment, 101st, 102nd. 100th Constitutional Amendment Act passed in the year 2015. It was basically to resolve land boundary dispute between India and Bangladesh. The External Affairs Minister has met with Sheikh Hasina, the Prime Minister of Bangladesh, recently. 101st Constitutional Amendment Act of 2017 dealt with GST. 102nd Constitutional Amendment Act talked regarding the establishment of National Commission for Backward Classes, which we will discuss, very important. 103rd Constitutional Amendment Act in 2019. This was 2018. This was 2017. This was 2015. This was 2019. It provides for 10% reservation for economically weaker sections of the society. Sometimes factual questions are asked. 2 factual questions by the UPSC. That's why UPSC is unpredictable. You may be asked about match the following. You may be asked about the years as well. Then 104th Constitutional Amendment Act in 2021, which spoke of what? Extension of SC/ST reservation in legislatures. And then we have the 6th, 105th Constitutional Amendment Act, which we will discuss today, which restored the powers of the states to have their own socially and educationally backward classes of citizens list, SEBC list, which was deprived by the court. And this position of the states was restored by the constitutional amendment called 105th, and we will discuss this slightly later. Let's look at this question. 104th Constitutional Amendment Act deals with what? Initially, there was political reservation for SCs and STs in parliament, in state legislatures for 10 years. Then it got extended number of times, and the last was 2020. So this reservation for SCs and STs should have ended on 26 January 2020. But then 104th Act was passed in 2019, which extended this political reservation for SCs and STs by another 10 years. So this is correct. And at the same time, there used to be a reservation for Anglo-Indians as well. 2 Anglo-Indians, if the president is satisfied that Anglo-Indians are not significantly or sufficiently represented in Lok Sabha, he could have nominated 2 Anglo-Indians to Lok Sabha. The same power was given to the governor of a state. the governor of a state, if he is satisfied that the members of the Anglo-Indian community are not sufficiently represented in the state legislative assembly, he could have nominated one MLA from Anglo-Indian community to legislative assembly. But this was discontinued by this 104th Amendment. So 104th Amendment extended the political reservation only for SCs and STs. It decided not to extend this reservation further for Anglo-Indians, correct? And it is this Article 334 which talks about SCs and STs. So this reservation is mentioned under Article 334. So Constitution 104th Amendment Act 2019 deals with 1, it deals with 2, it deals with 3. So D, all of the above is the right answer. Let's look at something else. The Speaker and Deputy Speaker, they are in the news. Deputy Speaker of Lok Sabha is in the news because we don't have a Deputy Speaker. Why we don't have a Deputy Speaker, we don't know. In fact, there is a petition pending in the Delhi High Court as well, asking why we don't have a Deputy Speaker. Constitution says the members of the Lok Sabha shall elect the Speaker and the Deputy Speaker as soon as possible. But the time period is not mentioned. I don't know why, but the government is reluctant to fill this post of the Deputy Speaker of Lok Sabha. So let's look at Speaker and Deputy Speaker. The Speaker of the Lok Sabha is elected by the members of Lok Sabha by effective majority. Is elected by the members of Lok Sabha but by simple majority. The Speaker of the Lok Sabha is removed from his office by effective majority. So to elect a Speaker, the Speaker shall have to be the member of the Lok Sabha. And anyone who is a member of the Lok Sabha can contest election to the office of the Speaker, and whoever gets simple majority, more than half of the members present and voting, such an individual is elected by the Lok Sabha members as the Speaker of the Lok Sabha. But the Speaker can also be removed from his office. And the Speaker is removed by the members of Lok Sabha when they pass a resolution by effective majority. So election by simple majority, removal by effective majority. So first statement is incorrect. According to the Constitution, the Speaker has to be a member of the ruling party or a ruling coalition. No, it's a convention. Since Speaker, he has a lot of powers. He is the custodian of the Lok Sabha. He is the interpreter of the rules of business and procedure of the Lok Sabha. Speaker has a lot of power. He is responsible. He's like a class monitor in Lok Sabha. That is why the Speaker is almost always a member of the ruling party or the ruling coalition, because no ruling party or coalition would want to give the member of the opposition this role of the Speaker, because Speaker is a very important role. But it's not mentioned in the Constitution. Constitution only says the Speaker is elected by the members of the Lok Sabha from amongst themselves. So one member of the Lok Sabha, any member, can be elected as the Speaker by the Lok Sabha MPs. But this is not mentioned in the Constitution, that the Speaker has to be the member of the ruling party or coalition. No. Third, in the warrant of precedence, the Speaker comes next only to the President, the Vice President, the Prime Minister and the Bharat Ratna awardees. It's wrong. Select the correct option from below. None of the statements are correct. D is the right answer. In the warrant of precedence, we have the President, then Vice President, then the Prime Minister, then we have governors in their respective states. And why is this important? Again, Telangana governor, she is alleging something. She alleges that whenever I go, no MLA or MP or the minister is accompanying me. So the warrant of precedence, my protocol is getting violated. So that is why this warrant of precedence can be important. First is President, then Vice President, then Prime Minister, then governors in their respective states. Then we have the former presidents. Then we have the union ministers. Then we have the Chief Justice of India and the Speaker. The Speaker and the Chief Justice of India, they have the same position in the warrant of precedence. So this statement is wrong because it says President, Vice President, Prime Minister and Bharat Ratna awardees. Then we have the Speaker. No, Bharat Ratna awardees come later. They are mentioned at 7A position in the warrant of precedence. So none of these statements are correct. D is the right answer. Let's look at another question. The Speaker of the Lok Sabha is empowered to disqualify a member of the Lok Sabha on which of the following grounds? A. Defection, unruly behavior, office of profit. 4. When a member tears a bill copy and enters the well of the House. Unruly behavior when a member tears a bill and enters the well of the House, when the member is raising slogans, when the member is displaying a postcard or a slogan, all these are considered to be acts of misbehavior. And under these acts of misbehavior, the Speaker has the power to suspend an MP. Suspend. The question is asking disqualify. So there is a difference. Disqualification is for the entire term. You are disqualified. You are disqualified now, that means you are no longer part of Lok Sabha. You can get elected again, then you can be part of Lok Sabha again, but till you are re-elected, you are disqualified. Suspension cannot be for more than remainder of the session. So if it's a budget session, and the budget session is, let's say, for another 2 months, the Speaker has the power to suspend a member of the Lok Sabha. The maximum period of suspension can be the remainder of the session. But the Speaker cannot disqualify you for your unruly behavior, for when a member tears a bill copy and enters the well of the House. No, the Speaker cannot disqualify you. Speaker can only suspend you. And remember something else as well. This power is given to the Speaker. This power is not given to the Chairman of Rajya Sabha. The Chairman of Rajya Sabha cannot suspend an MP of Rajya Sabha. The Chairman of Rajya Sabha cannot suspend. Then who can suspend? Members of the Rajya Sabha. They have to pass a resolution, and basis that resolution, that unruly member can be suspended from Rajya Sabha. So the power to suspend an MP is given to the Lok Sabha Speaker, but the power to suspend a Rajya Sabha MP is not given to the Chairman of Rajya Sabha. This power is given to the House. The House can suspend that member. And in fact, we saw some MPs were suspended in Rajya Sabha, not by the Rajya Sabha Chairman, but by Rajya Sabha itself. And that suspension was because of voice vote. When through a voice vote, the members of the Rajya Sabha decide to suspend some of the MPs of Rajya Sabha. The Speaker of the Lok Sabha is empowered to disqualify a member of Lok Sabha on which of the following grounds? Defection, yes, this comes under 10th schedule of the Constitution. For unruly behavior, no. When a member tears the bill copy, no. Office of profit, no. Who can disqualify an MP on the grounds of office of profit? President. If you are a member of the Parliament, President can disqualify you on the grounds of office of profit. If you are a member of the state legislature, who can disqualify you? Governor. But President or the Governor cannot disqualify a member on his own. They have to refer this matter to Election Commission of India. And the report of Election Commission of India is binding on President or the Governor. Under Article 105, the members of the Parliament can also be disqualified and there are various grounds of disqualification. One is adjudged insolvent, if an MP is declared bankrupt. 2, if there is a change in the nature of citizenship. 3, if this individual is holding the office of profit. 4, if this individual is of mental infirmity, mental unsoundness. On all these grounds, President or the Governor has the power to disqualify these legislators. But President or the Governor cannot act on their own. They have to refer this matter to the Election Commission of India, and whatever report is prepared and submitted by Election Commission of India, that becomes binding on the President or the Governor. So only 1A is the right answer. Let's look at another question. These financial committees of the Parliament, they were in the news throughout the last 2 to 3 years, primarily because of the pandemic. Let's look at some of the questions. Which of the following statements, and I think that I have a hunch that definitely 1 or 2 questions are going to be asked from these committees. So please look at these questions carefully. Which of the following statements regarding the Estimates Committee is or are correct? It consists of 30 members from Lok Sabha only. Only Lok Sabha MPs are part of it. Yes, factual question. It is also known as the Continuous Economy Committee. This is also correct. You may also be asked which of the following committees are known as or is known as Continuous Economy Committee. That's the Estimates Committee. The Public Accounts Committee is known as the twin sister of the Estimates Committee. This is also correct. If you look at the book written by Subhash Kashyap, he writes about these committees beautifully. He mentions that PAC is known as the twin sister of the Estimates Committee. Fourth, the committee cannot examine the policy as approved by the Parliament. This is slightly tricky, dicey. Can you tell me what is the answer? Is it 1, 2, 3 or is it 1, 2, 3, 4? Is it all of the above? All of the above. The committee cannot examine the policy as approved by the Parliament. But there is one difference. The committee can examine the working of this policy. Sir, what's the difference? Let's say a policy has been approved by the Parliament. Let's say MG Narega, Maganrega, Mahatma Gandhi National Rural Employment Guarantee Act, where for 100 days of paid employment is a statutory right provided to people in rural India. So this is the policy which has been approved by the Parliament. Can Estimates Committee examine this policy? No. But how this policy is working? If this policy is not working effectively and it leads to wastage, since Estimates Committee is the Continuous Economy Committee, it looks at this wastage. It cannot examine the policy, but the working of this policy, because this working leads to wastage, it is the job of the Estimates Committee to present this report of wastage to the Parliament. That is their job. That's the job of the Estimates Committee. So D is the right answer. All the members of Estimates Committee are from Lok Sabha only. So this is something very important, can be asked in your prelims exam. Let's look at the PAC, another committee, Public Accounts Committee, which was in the news because of some very important reports prepared by the PAC. The PAC consists of, in fact, the PAC is considered to be the oldest financial committee of the Parliament. In fact, the origin dates back to 1921. And this committee was set up in 1921 in the pre-independent India. And the creation or the establishment of this committee was recommended by the Montagu-Chelmsford reforms of 1919. That's why it's also known as the oldest financial committee of the Parliament. So if the question is, which of the following is known as Continuous Economy Committee? It's the Estimates Committee of the Parliament. Which of the following is the oldest financial committee of the Parliament? It's the Public Accounts Committee. And what is the role of the Public Accounts Committee? The role is to look at and examine various audit reports prepared by CAG. So CAG prepares various types of audit reports. One is the audit report on appropriation account, the other on Finance Act or Finance account, and the third one on public sector undertakings. All these audit reports of the CAG are examined by Public Accounts Committee. And that is why CAG is known as the friend, philosopher, and guide of PAC. Can be another question. For which of the following committee, PAC, for which of the following committee, financial committee, the CAG is the friend, philosopher, and guide, and that is the PAC. Let's look at the question. The PAC consists of 22 members. Correct or incorrect? Correct. In fact, I think this question was asked in 2013 prelims. This question was asked. But we have seen that some of the questions have been repeated as well. I think more than 3 times the question on DPSP has been repeated. The question on parliamentary democracy has been repeated by the UPSC. So there is no guarantee why questions cannot be repeated. So PAC consists of 22 members, correct? Half of its members are from Lok Sabha, correct or incorrect? Incorrect. 15 are from Lok Sabha, 7 are from Rajya Sabha. Third, since its inception, Rajya Sabha members have been part of the PAC. Now, it was only in 1954-55 that Rajya Sabha members became part of the Public Accounts Committee. So statement 3 is incorrect. Only 1 is correct. The question is asking select the correct option. A is the right answer. In fact, one more thing. There is a convention. Convention, unwritten rule, not mentioned anywhere, but something that we follow. The chairperson of this Public Accounts Committee is normally from the opposition party. Normally, the chairperson of this Public Accounts Committee is from the opposition party. This is something that is relevant for your exam. Let's look at another question. It's a very important question, very, very important question. If I was the examiner paper setter, I would include this question. There is a business advisory committee only in the Lok Sabha. The Speaker of the Lok Sabha is its ex officio chairman. Which of the above statement is or are correct? 1 is incorrect, 2 is correct, B, only 2 is the right answer. There is a business advisory committee in Lok Sabha. Look at these facts, very important. There is a business advisory committee in Rajya Sabha as well. But what is the role? The role is there are various bills which are to be introduced in the parliament. What is the amount of time that we have to allocate for these bills? That's one principal role, principal function of a business advisory council or a business advisory committee. In Lok Sabha, it has 15 members and the Speaker is the chairman of this business advisory committee. In a Rajya Sabha, there are only 11 members. Deputy chairman is also part of it. Deputy chairman of Rajya Sabha is also part of business advisory council. But the chairman of Rajya Sabha The Vice President or the Chairman of Rajya Sabha is the ex officio Chairman of this Business Advisory Committee as well, which tells us something else. There is one privilege which is available to the Deputy Speaker of Lok Sabha. And what is that privilege? Whenever Deputy Speaker is nominated to a committee of Lok Sabha, he or she invariably becomes the chairperson of that committee. So if I am a Deputy Speaker of Lok Sabha, I am nominated to a committee of the Parliament, I become the chairperson of this committee. That is not the privilege available to the Deputy Chairman of Rajya Sabha, which means despite the fact that Deputy Chairman is part of this Business Advisory Committee, but he is not the Chairman. It's the Vice President, it's the Chairman of Rajya Sabha who is the Chairperson of this Business Advisory Committee. But one more important difference between these two committees is that Business Advisory Committee of Rajya Sabha, it has one extra role. The role is to decide, to allot the time for private members' bills as well as resolution. The job of the Business Advisory Committee is to allocate time for various legislative agenda, for various bills, for various resolutions. The Business Advisory Committee in Rajya Sabha performs this role for private members' bills as well, private members' resolutions as well. They decide, this committee decides, what is the time that we have to allocate to the government legislation, to the government bills, as well as to the private members' bills, as well as the private members' resolutions. But the Business Advisory Committee in Lok Sabha only does this for government business. It only deals with the time that should be allocated to government bills, to government resolutions. Because for Lok Sabha, there is a separate committee, Committee on Private Members' Bills and Resolutions. It is the job of this Committee on Private Members' Bills and Resolutions to allot the time meant for private bills, private resolutions in Lok Sabha. But there is no such need for such a committee in Rajya Sabha because the same Business Advisory Committee allocates time to government business as well as to the private business. That is why this question becomes important. So what is the question? There is a Business Advisory Committee only in Lok Sabha? No, because it's there in Rajya Sabha as well. The Speaker of the Lok Sabha is its ex officio chairman. Yes, the committee which is there in Lok Sabha, the chairman is the ex officio, the Speaker is the ex officio chairman. This is correct. Which of the above statements are correct? Only two. B is the right answer. Now let's look at something else. Committee on Subordinate Legislation. CAA, Citizenship Amendment Act. It was passed in the year 2019. According to this act, 6 religious minorities from the 3 neighboring countries of Pakistan, Afghanistan and Bangladesh. 6 religious minorities belonging to Hindus, Christians, Buddhists, Jains, Sikhs, Parsis. They shall not be deemed as illegal migrants. Because we know that we have a Citizenship Act which was passed in 1955, which has been amended multiple times. And according to this act, an illegal migrant is not eligible for Indian citizenship. But in 2019, this Citizenship Act was amended. The CAA of 2019, it says that if you are belonging to either of these 6 religious minorities from 3 countries, Pakistan, Afghanistan, Bangladesh. And if you have entered India on or before 31st December 2014, you shall not be deemed as illegal migrants. And when you are not deemed as illegal migrants, that means you are eligible for citizenship. That means you are eligible for citizenship through naturalization. And for these 6 religious minorities, the period of naturalization was reduced from 11 years to 5 years. Clear? But why are we discussing this? Because this act has not been implemented yet. Why it has not been implemented yet? Because to implement this law, we need rules. Who will have the power to make these rules? Executive, the bureaucracy. And all these rules, once they are made, they are to be examined by the Committee on Subordinate Legislation of the Parliament. So these rules, there is something called Delegated Legislation. Parliament makes a law in a skeleton format. It does not go into the nitty-gritties of its implementation. For that, the powers are delegated to the executive, to the bureaucracy. That's what we call delegated legislation. But to ensure that whenever these rules are made by the bureaucracy, these rules are consistent with the law passed by the Parliament. These rules are to be analyzed, examined by a committee of the Parliament called Committee on Subordinate Legislation. And it is this Committee on Subordinate Legislation which has given extension after extension after extension to the Ministry of Home Affairs to make rules for the implementation of Citizenship Amendment Act 2019. That's why this question becomes important. So question number 1. Each house of the Parliament has its own Committee on Subordinate Legislation. Yes, both Lok Sabha as well as Rajya Sabha have these committees. The committee consists of 15 members elected by the House. Read the statement carefully. The committee consists of 15 members, yes, but not elected by the House. Nominated by the Speaker for Lok Sabha, by the Chairman for Rajya Sabha. So read the statements carefully. So statement 2 becomes incorrect. The committee only examines acts and not bills. Which of the above statements is correct? A, only one is the right answer. The job of this committee is not only to examine the act. The job of the committee is also to examine those bills which empower delegated legislation. In a sense, if there is a bill and one of the provision of this bill is that we are going to delegate the power, Parliament is going to delegate its rule-making power to the bureaucracy. Since this bill talks about the power of the bureaucracy to make rules, such bills can also be examined by this Parliamentary Committee on Subordinate Legislation. So both these statements are incorrect. One is correct, only 1A is the right answer. Let's look at another question. And this is something that I told you we will discuss. Constitution, 102nd Constitutional Amendment Act, 2018. Why are we discussing this now? Because it is in the news. And in fact, because of this 102nd Amendment and because of something that Judiciary did, another Constitutional Amendment Act was passed called 105. We will discuss. The year was 2018 when NCBC, National Commission for Backward Classes, which previously was a statutory body. Now, body is a statutory body if it is created by the law of the Parliament. Body is a constitutional body if it is created by the Constitution. For example, Election Commission of India is a constitutional body. Union Public Service Commission is a constitutional body. State Public Service Commission is a constitutional body. Finance Commission is a constitutional body. National Human Rights Commission is a statutory body. Right? Why statutory body? Because it's created by the law passed by the Parliament. Central Information Commission is a statutory body created by the law passed by the Parliament, RTI 2005. Clear? So prior to 2018, prior to this constitutional amendment, National Commission for Backward Classes was a statutory body. Now it was given a constitutional status. And at the same time, this 102nd Constitutional Amendment Act talked about a central list. Central list of socially and educationally backward classes of citizens. So we have a central list of SCs, we have a central list of STs. Another central list was created called Central List of Socially and Educationally Backward Classes of Citizens. This is where there was a confusion. This is where there was a doubt. The doubt was, should there only be a central list for SC, BC, or can states have their own list? Matter went to the court. The court said no. States cannot have their own list of socially and educationally backward classes of citizens. We can only have a central list, and it is the power of the president to add to this list, to add groups to this list. This power is not given to the states. So basically, Supreme Court, what it did, it deprived the powers of the states. It deprived the powers of union territories as well. That states and union territories, you cannot have your own list of who are socially and educationally backward. We can only have a central list, and this central list is to be added only by the central government, by the President of India. There was a lot of hue and cry that the Supreme Court has snatched the powers of the states, which is violative of federalism, and federalism is part of the basic structure of Indian Constitution. Accordingly, what happened? 105th Constitutional Amendment Act was passed in 2021. And it is this 105th Constitutional Amendment Act which restored the powers of states and union territories. That now states and union territories, they can have their own list of socially and educationally backward classes of citizens. And in fact, this list can be different from the central list. That means there may be groups who are part of state list, but they are not part of the central list. There may be groups who are part of the central list, but they may not be part of the state list. This is the backdrop. And in this backdrop, let's look at the question. The question is, states and union territories have the authority to prepare and maintain for their own purposes a list of socially and educationally backward classes, entries in which may be different from the central list. This is correct. National Commission for Backward Classes is a constitutional body. Yes, it is. National Commission for Backward Classes consists of a chairperson, vice chairperson, and 3 other members. Correct? Which of the above statements is or are correct? D. All of the above is the right answer. But let's look at something else. This chairperson, vice chairperson, and members. This chairperson shall belong to the socially and educationally backward class of citizens. Chairperson, vice chairperson, and 3 other members who are appointed to this National Commission for Backward Classes. Appointment is made by the President of India. But President can appoint somebody look at me carefully. President can appoint somebody as the chairman of National Commission for Backward Classes, and this person shall belong to socially and educationally backward class of citizens. Clear? Out of these, vice chairperson and 3 members, at least one should be woman. That's another requirement, can be important for your prelims. And 2 should be belonging to socially and educationally backward class of citizens. This can be very important, relevant for your examination. But not just this, something else. This chairperson of National Commission for Backward Classes, appointed by the President, but can be removed as well. Can be removed on the grounds of misbehavior, very important details. Can be removed also on the grounds of mental unsoundness, or the more specific term for this is infirmity of mind or body. Can also be removed on the grounds of if he has indulged in paid employment outside his office, if he has been adjudged insolvent, if he has been convicted by courts on grounds of moral turpitude. Look at me carefully. The chairperson of the National Commission for the Backward Classes can be removed. How? By the President on the grounds of misbehavior. But whenever a chairperson of NCBC is to be removed on the grounds of misbehavior, for that the President has to refer this matter to the Supreme Court, and the Supreme Court will conduct an inquiry on the basis of this report by the Supreme Court. Once it has conducted this inquiry, can the President remove the chairperson of the National Commission for Backward Classes on the grounds of misbehavior? So if the chairperson is to be removed on the grounds of misbehavior, for that the President shall have to necessarily refer this matter to the Supreme Court for inquiry. Basis that inquiry, the chairperson can be removed. But the chairperson can be removed on other grounds as well. Infirmity of mind or body. I am the chairperson, but my mental capability has gone for a toss, or I am subjected to suffering from some physical deformity because of which I cannot fulfill the duties of my office. If I am engaging in paid employment outside of my office, if I have been declared insolvent, bankrupt, or if I have been convicted by the judiciary on charges involving moral turpitude, in all these cases the President can remove me without referring this matter to the Supreme Court. That's the difference. So here no inquiry by the Supreme Court is necessary. On the grounds of misbehavior, there shall be an inquiry by the Supreme Court. And these provisions are similar to another constitutional entity. And that another constitutional entity is chairperson of your very own UPSC, chairperson of State Public Service Commission. State Public Service Commission chairperson, who appoints them? Governor. So the chairperson of a State Public Service Commission is appointed by the governor, but cannot be removed by the governor. can be removed by the President only. And these are the grounds on the basis of which the President can remove. If it's the ground of misbehavior, for that the inquiry by Supreme Court is a must. And if it is these grounds, then President without an inquiry can remove you from your office. Clear? So this is a very important question. Let's look at another question. Prime Minister's Citizen Assistance and Relief in Emergency Situations Fund, also known as the PM CARES. The PM CARES started because of the COVID-19 pandemic, voluntary contribution so that people can contribute to this fund, and the money that gets deposited in this fund can be used for various COVID-related relief. Lots of controversy. Some said that PM CARES donations are not subject to RTI. Some said if we already have a Prime Minister's National Relief Fund, why do we need a PM CARES? But we haven't seen a question asked by UPSC on PM CARES, neither last year nor before that. We might expect a question on PM CARES this year. So let's look at this question. PM CARES. The fund consists entirely of voluntary contributions from individuals, organizations, and does not get any budgetary support. Correct. There are some funds which get budgetary support. For example, when the union budget is passed, this budget makes allocations for some funds. For example, the Nirbhaya Fund. And Nirbhaya Fund is in the news as well because lots of states, they are not in a position to effectively utilize the funds available in the Nirbhaya Fund. Nirbhaya Fund, which was passed by the central government based on a law passed in 2013. It was in memory of Nirbhaya, who was gang raped in a moving bus on, I think, December 16, 2012. One such individual rapist is released because he was a juvenile at the time of the commencement of the crime. And that Juvenile Justice Act was passed in response to that horrific incident. And there has been an amendment to Juvenile Justice Act as well in 2021, which we will discuss either today or tomorrow. So that's in this backdrop. Let's look at the question. Nirbhaya Fund, it gets contributions from budget as well. So budgetary allocation is given to Nirbhaya Fund. But that is not something which is given to PM CARES. The money that is in PM CARES is entirely from the voluntary contributions from individuals, corporates, foreign entities as well. The donations to PM CARES would qualify for 100% exemption under the Income Tax Act. Whatever you donate is exempted from the Income Tax Act. Third, donations to PM CARES Fund qualify to be counted as corporate social responsibility expenditure under the Companies Act. The Companies Act, which was passed in 2013, according to which all the companies of a certain value, we don't have to go too deep into those technicalities, but long story short, if there is a company which is making profit, 2% of the net profit over the past 3 years, they have to donate for various corporate social responsibility expenditures. And these companies, they can also donate 2% of their net profit over the past 3 years to PM CARES, and donation to PM CARES would qualify as corporate social responsibility. PM CARES has got exemption under FCRA to accept donations and contributions from individuals and organizations based in foreign countries. This is also correct. So PM CARES has got the FCRA license, and only once you get the FCRA license can you get donations from the foreign countries. All these statements are correct. D is the right answer. And in PM CARES, Prime Minister is the chairperson, ex officio chairperson. And then we have other trustees. Who are these other trustees? Home Minister, can be asked in your examination. We have Defense Minister, and we have the Finance Minister. Prime Minister is the ex officio head of this PM CARES, and we have other trustees, Home Minister, Defense Minister, and the Finance Minister. These are the other trustees, ex officio trustees of PM CARES. Similar to this, we have Prime Minister's National Relief Fund. And this Prime Minister's National Relief Fund, because the confusion, the doubt, or the controversy is that if we already have a Prime Minister's National Relief Fund, then what is the need for a PM CARES? Prime Minister's National Relief Fund was created neither by a law nor by a cabinet decision. It's a trust. And ultimately, it was on the basis of the appeal made by the then Prime Minister, Pandit Nehru, who asked people to contribute because there was a massive migration of people into India from what became Pakistan. So to provide support and assistance to these migrants, on his appeal, a fund was created called Prime Minister's National Relief Fund. Be that as it may, let's look at another question. Election Commission of India's sweep is what? Systematic voters' education and electoral participation. That's the full form of sweep. It's a flagship program of the Election Commission of India for voter education. It is not a proposal to extend online voting to the NRIs. It is not a proposal to list all the criminal cases against the election candidates on their website. It is a flagship program for voter education. In fact, there was a Supreme Court judgment on the criminalization of politics as well, where proposal to list all criminal cases against the election candidates on its website, this was basically given by the Supreme Court. Supreme Court said if there are political parties who are giving tickets to candidates with criminal past, it has to explain to the voter why. Because right to know is a fundamental right under Article 19(1)(a) of the Constitution. There was a public interest litigation filed by Association for Democratic Reforms many years ago, on the basis of which the Supreme Court was asked that voters should have the right to know the antecedents of the candidates contesting elections. The voters should need to know the educational qualification of the candidates contesting elections, the amount of property in the name of the candidate and their spouses, the number of criminal cases pending against them. And once this information is available, then the voters will be able to make informed choice as to which candidate they might want to vote for. And this right to know is a fundamental right under Article 19(1)(a) of the Constitution. But then we saw that even if political parties, they are explaining to the public that this person is having a criminal past, but political parties are not explaining why they are giving these tickets to the criminals, to the people with criminal past. Previously, the political parties would say that these candidates, we are giving them tickets because they are winnable. They can win elections for us. That is why we are giving them tickets. In a landmark judgment last year, the Supreme Court said no. Explain to the public. And explain this on your website. Have a prominent place on your website where you are explaining why you are giving tickets to candidates with criminal past. And don't you dare only talk about winnability factor. Forget about winnability. Exactly why are you giving tickets to candidates with criminal past? And not just that, not just publish on your website, publish in 2 prominent newspapers as well. Publish all these reasons why you are giving tickets to the candidates with a criminal past, and publish these reasons on your website at a prominent location and in 2 newspapers as well, prominent newspapers as well. But this is not something related to sweep. Sweep is primarily a flagship program for voter education, systematic voters education and electoral participation. Let's look at another question. Which of the following statements regarding a state election commissioner is or are correct? Why? State election commissioner in news because of what has happened in Telangana. Not Telangana, what happened in Andhra Pradesh and what also happened in Goa. Because of these recent current affairs issues, this is the topic, becomes relevant for your exam. The CEC is appointed by the governor of a state. The tenure of the CEC is mentioned in the constitution, while a state electoral officer is a senior bureaucrat. A bureaucrat or no bureaucrat can be appointed as the SEC or State Election Commissioner. We have a constitutional body called Election Commission of India, which is responsible for the conduct of elections to Lok Sabha, Rajya Sabha, State Legislative Assembly, Legislative Council, President, Vice President. But we have State Election Commission, and this constitutional body was created because of 73rd and 74th Amendment in 1992. And the purpose of the State Election Commission was to organize elections to panchayats and municipalities. Clear? So an independent office was created, constitutional body was created. And this SEC, State Election Commissioner, is appointed by the governor, but he can be removed in the same manner and on the like grounds as the judge of a high court. How is the judge of a high court removed? Just like the judge of a Supreme Court is removed. By the president, based on the statutory resolution passed by both houses of the parliament by special majority, on the grounds of proved misbehavior and incapacity. That means State Election Commissioner is appointed by the governor but can be removed by the president. Other conditions of service as to what should be the salary, what should be the tenure, all these are provided by the law passed by the state legislature. So all the conditions of service of the State Election Commissioner will be decided by the law passed by the state legislature, and this is where the controversy arose in Andhra Pradesh. The term of this SEC was mentioned as 5 years, but since the Legislative Assembly has the power to define the other conditions of service, an ordinance was promulgated by the governor of Andhra Pradesh, because of which the term of the SEC was reduced from 5 to 3 years. And this was primarily done to remove the State Election Commissioner, because State Election Commissioner in Andhra Pradesh and the Chief Minister, they were in conflict with each other. Chief Minister wanted State Election Commissioner to do something, but the State Election Commissioner is not doing it. He wanted elections to be conducted to panchayats. The State Election Commissioner said no, because of the COVID-19 we can't have elections. And ultimately the term of the SEC in Andhra Pradesh was 5 years. But now, since the state legislature has the power to make conditions of service for the State Election Commissioner, for that an ordinance was promulgated. Because of this ordinance, the term was reduced from 5 to 3 years, effectively removing the State Election Commissioner. Matter went to the court struck down that ordinance, saying you cannot remove State Election Commissioner like this, because he has been given a protection in the Constitution. He can be removed just like the judge of a high court is removed. And in Goa, bureaucrats were appointed as state election commissioners. Supreme Court said you're making mockery of the Constitution. A state election commissioner has to be an independent authority. If you are appointing a bureaucrat and giving him an additional charge of a state election commissioner, then how do we ensure the independence of this office? No bureaucrat shall be appointed as the state election commissioner. But we do have senior bureaucrats as the chief or the state electoral officer. Who is an electoral officer? Basically, his job is to assist the Election Commission of India in the preparation of electoral rolls. So this senior bureaucrat can be a state electoral officer, but no bureaucrat can be appointed as the SEC. This is correct. The SEC is appointed by the governor of a state. This is also correct. The tenure of the SEC is mentioned in the Constitution. No, it is not mentioned in the Constitution. The tenure, the conditions of service are decided by the law, and this law should be passed by the state legislature. So which of the above statements is or are correct? 1 and 3, C is the right answer. Now let's look at another question. Which of the following statements regarding the Film Certification Appellate Tribunal is or are correct? We have one body which is also known as censor board. Although it's not a censor board, it's a certification board called CBFC, Central Board for Film Certification. What is the job of this organization? To certify films. And which are these certificates provided? U, unrestricted viewing. That means any film given a U certificate, anybody can watch it without any restrictions. UA, parental guidance is necessary. For kids below 12 years. If kids below 12 years, they want to watch this movie which has been given a certificate of UA, the parent should accompany. Then we have A, which is allowed only for adults. An adult is somebody who is above the age of 18. And then we have S. S is in the sense for a specialized group of engineers, doctors, or scientists. It's only for those selected people that they can watch these movies. I am a filmmaker. I made a movie. CBFC has to certify whether this movie comes under U, UA, A, or S category. And what if I'm not happy with the decision given by the Central Board for Film Certification? What I could have done, I could have approached a tribunal called Film Certificate and Appellate Tribunal. And this Film Certificate and Appellate Tribunal, it was a statutory body, that means created by the law passed by the Parliament. And which law? This statutory body was set up by the Ministry of Information and Broadcasting. The year was 1983. And the main job of this committee, of this tribunal, was to hear appeals filed under Cinematograph Act. And it is this Cinematograph Act under which appeals can be filed if you're not satisfied with the decision given by the Central Board of Film Certification. So statement 2 also becomes correct. The tribunal was headed by a chairperson and had 4 other members. This is also correct. And this tribunal was abolished in the year 2021. That is why we are discussing this question. This is also correct. So D, all of the above is the right answer. In abolishing this tribunal, tomorrow we'll discuss the Tribunals Reforms Act of 2021. A far-reaching law was passed by the Parliament which abolished this FCAT as well, this tribunal as well. So if there is no FCAT, and as a filmmaker, if you're not satisfied with the decision given by CBFC, then what you have to do, you have to approach the High Court. So a filmmaker not satisfied with the decision given by Central Board for Film or Film Certification, instead of now approaching the FCAT, they will have to now approach the High Court. And there were few filmmakers who protested against this move, calling this move regressive, against the freedom of speech and expression, so on and so forth. But since this was in the news, it becomes a potential question for your prelims examination. That is it for today. Thank you for being with us. See you tomorrow, 7:30 p.m. to discuss another set of very important, interesting questions for Indian polity for prelims 2022. And before you go, don't forget to press the like button. Comment once the stream is over. Let us know your thoughts. And come back tomorrow, 7:30 p.m. Till then, have a great time. Good evening.